Michael Popok, Legal AF. The best way to start this hot take: dismantling Donald Trump's ridiculous separation of powers argument that he lost at the D.C. Court of Appeals, in which he tried to argue that he was above the law, that any president is above the law, that his actions, no matter what they are, ministerial, discretionary, or official, or criminal, cannot be reviewed by a court under our three co-equal branches of government, showing a fundamental misunderstanding and misapprehension of how our constitutional republic works. The best way for me to start that dismantling on this particular hot take is with the language of the D.C. Court of Appeals, which I think is the most hard-hitting and the most influential aspect of their order, their 57-page order. I'm going to read it for you now. It starts on page 39. Then I'll back in to tell you why the separation of powers argument that Donald Trump constructed and was deconstructed by this three-judge panel will not only hurt him here, it has hurt him here because he's lost his appeal, and the United States Supreme Court, I believe, is going to affirm the D.C. Court of Appeals, but it will reverberate because he uses the same type of argument at the current Supreme Court level appeal of the 14th Amendment, Section 3, disqualification from the ballot issue that's going to be heard in oral argument this week. That's a lot. I'm going to do it all here. Let me start with the language written by this is a unanimous decision, a per curiam decision by the three-judge panel. I think it was written by Judge Pan, but who really knows? And listen to the language here. It's on page 39 over to 40 of their decision. Because I think it animates and drives this thought process, this approach drives the entire opinion that they wrote. Quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. He allegedly injected himself into a process in which the president has no role, the counting and certifying of the electoral college votes, thereby undermining constitutionally established procedures and the will of the Congress. To immunize former President Trump's actions would, quote, further aggrandize the presidential office, already so potent and so relatively immune from judicial review at the expense of Congress, citing a case called Youngstown. As Justice Jackson on the United States Supreme Court warned, and this is their quote, executive power has the advantage of concentration in a single head whose choice the whole nation has apart, making him the focus of public hopes and expectations. In drama, magnitude, and finality, his decisions so far overshadow any others that almost alone he fills the public eye and ear. No other personality in public life can begin to compete with him in access to the public mind through modern methods of communications. By his prestige as head of state and his influence upon public opinion, he exerts a leverage upon those who are supposed to check and balance his power, Congress and the courts, which often cancels their effectiveness. The three-judge panel goes on in their opinion from yesterday. We cannot accept further former Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and have their votes counted. At bottom, the opinion continues, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment, which is what Donald Trump is arguing, would mean that as to the president, the Congress could not legislate, the executive could not prosecute, because that's where the Department of Justice sits, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. Careful evaluation of these concerns leads us to conclude that there is no functional justification for immunizing former presidents from federal prosecution in general, or for immunizing former President Trump from the specific charges in the indictment. In so holding, we act not in derogation of the separation of powers, but to maintain their proper balance, citing Nixon versus Fitzgerald. Now, let me back into what we're talking about here. one of Donald Trump's major arguments. He made a few of them. That, you have to go through the impeachment process and a conviction before you can actually take him to a criminal court. That Article 3 judges don't have any ability to review under the separation of powers, that presidents are above the law under the separation of powers, right? And other related arguments. I'm going to focus here on the separation of powers argument because it reverberates in his other arguments at the United States Supreme Court. Here's a quick primer for those that are new to our system of government from around the world or just in general. Separation of powers means we got three co-equal branches of government: executive, legislative, and judicial. And each one of them has a role. While they are supreme in their respective spheres, right? Presidents can't try cases, courts can't run the White House, Congress doesn't try cases except in impeachment. They do their own thing, right? And as outlined in separate articles of the United States Constitution establishing our form of government. Now, those three co-equal branches of government, it doesn't actually say that in the Constitution. And so there's been Supreme Court decisions that have declared that. The major decision that's, the number one decision, if you were ranking on a scale of 1 to 100, like the top movies of all time, the top decisions of the United States Supreme Court of all time, it's Marbury versus Madison from 1807. That's a decision by Chief Justice Marshall that basically established once and for all that the Supreme Court had a role in its co-equal sphere to review the actions generally of the other two branches. Before that, the Supreme Court sort of didn't really have a mandate, didn't seem to really have a mandate about what to do. It was John Marshall that said, here's what this is our job description. We, as a United States Supreme Court, in order to hold up our end of the three co-equal branches of government bargain, we're going to be able to review the actions and the missteps and declare whether things are constitutional or not constitutional of the other two branches of government. Not to put us above them, but this is our job. This is what we contribute to our constitutional republic. That's from 1807. We studied in law school Marbury versus Madison. For 40% of my constitutional law class was devoted to Marbury versus Madison and its progeny and all the things that have emanated from it. Now, Donald Trump, of course, never went to law school. I'm not sure many of his lawyers did either because they missed the boat completely on Marbury versus Madison as the three-judge panel D.C. Court of Appeals ruled. They said, basically, you don't understand Marbury versus Madison. You misapprehend its fundamental underpinnings about the role of the Article 3 judges because all of the power of the federal courts, including the Supreme Court, are found in Article 3 of the Constitution, and we call them Article 3 judges. And Donald Trump argued, you can't review me. I'm above the law. When I'm doing anything that's got the if I do anything on presidential letterhead and on my stationery, you can't touch me. And of course, during the oral argument led by Judge Pan, we saw how ludicrous that was once she tested that theory and said, does that mean you could Mr. Sauer, your client, the then president, could order SEAL Team 6 to take out a political rival? And as long as he's wearing the presidency hat, he's immune? And they were like, well, that person would be impeached. Well, that's not what I asked you. I asked you if that he could be criminally prosecuted. And eventually, because Donald Trump's lawyers had to concede that even under their wacky world, their upside down world, that a president could be subject to criminal prosecution by an Article 3 judge, a regular federal judge. But in their theory, you had to go through this game of chutes and ladders to go through the impeachment process with Congress. But even then, when you came out the other end, you could be prosecuted, which, of course, in the decision, the three-judge panel said, see, even you think that a president can be prosecuted. It's all about timing. We're only having a fight about timing. You think it's got to go through an impeachment process, which it doesn't, because that makes no sense. What if he committed the crime the last 2 minutes of his presidency? There'd be no time for impeachment in the House and conviction in the Senate as a prerequisite to a federal criminal trial. That can't be it. But you even admit it, right? And so they took him to task for that. But the separation of powers argument, which is completely dismantled and is at the heart of the decision, I want to spend time with here on this hot take so you understand it. Donald Trump's position is that anything that he did as president, as long as it's under the imprimatur of being president, it cannot be criminally prosecuted after he leaves office. And that's just not, none of the cases leading up to this moment, whether it was cases about civil liability of a president for things outside his official conduct or even while president, or even a recent case that has Donald Trump's name on it, right? There's the Cy Vance versus Donald Trump case from 2020, which Kavanaugh, also concurred with, said effectively, presidents are not above the law, citing a long line of cases dating back to Marbury versus Madison, John Marshall presiding over other cases involving presidents and former presidents, and civil cases, including Fitzgerald versus Nixon, a case involving Bill Clinton, and every case inexorably led to the conclusion, right, as a stepping stone, that, of course, based on the whole body of law, right, all these cases standing on the shoulder of these other cases, that the next leap, the next link in the chain, that a president can't avoid criminal prosecution was obvious. I mean, in Vance versus Trump from 2020, Donald Trump should know about it, has his name on it. They ruled and they've ruled in previous matters, that a president is not above having to respond to criminal process because there was a criminal subpoena that was issued about his actions, Donald Trump's actions while he was president. And they declared forevermore, and the Supreme Court, of course, this is the Supreme Court decision, that he has to comply with the subpoena. He doesn't have immunity. So that next step is not that big of a leap, to argue that an Article III trial judge and an indictment out of a grand jury can be applied to a former president for actions while he was president. Now, there was a lot of debate during the 3-judge panel oral argument that we listened to a month ago. Each one of the judges, Judge Pan, sort of in the center, I think really being the chief judge in this case, Judge Henderson, who was a Bush appointee, and Judge Childs, who was appointed by Biden like Judge Pan, they each seem to have a different angle, and you can see it. You can see the struggle to reconcile their positions and to get this 57-page ruling. Everyone's tapping their foot, including on Legal AF, like, where is this decision? Because we want the case returned to Judge Chutkan as quickly as possible to set the trial date. And we know there's another step here going to the United States Supreme Court. So I thought it was going to be ruled on in like 4 days. But look, it took them 57 pages to reconcile their positions. Each judge took a different shot. Judge Childs was concerned about jurisdiction, whether they even had jurisdiction to hear the case, and whether this should wait until the end of the criminal trial of Donald Trump and be taken up on appeal at the end, like a normal appeal. In other words, why are we here on an interlocutory appeal early before the end of the case? And there's 10 pages of the 57 that are devoted to whether the court even has jurisdiction, which they finally concluded that they did, because this is an important historical matter, and the decision will have, a major impact on the disposition of the case. And there's a case called Midland Asphalt, not to bore you to tears, that applied. But that was a big chunk of the case, and I could tell from reading it that was the Judge Childs section of the brief. The section that Judge Henderson obviously led on in the brief had to do with official acts of the president and discretionary acts of the president, because those were her line of questions during the oral argument to John Sauer. And there, Donald Trump took the position that whatever he did is an official act, and all official acts are immune, which got them into trouble and got them wrapped around their axle on the SEAL Team 6 argument. Can you take out can you set fire to the White House? Is that okay? Things like that. So that section about official acts and discretionary acts, that you could tell was written by and led by Judge Henderson. Where she came out on that was against Donald Trump, which was, yes, discretionary acts within your official duties are not reviewable by a federal court. That has to be the body politic voting you in or out of office. But things that are your official duties, or things that are assigned to you by Congress, or things within that world, that is reviewable by a court. Of course, it has to be. Otherwise, we've lost our checks and balance. We've lost oversight over the presidency. And that can't be what the founding fathers, or our entire constitutional structure would crumble and fall at our feet if that were the case. If, the logical conclusion of Donald Trump's argument. And that got us into the separation of powers argument, which I think was really led by Judge Pan in her writing. And here's what they said there in the quotations that I think are very, very important on separation of powers. So firstly, now you understand the separation of powers. But here's the quoting I think that is very, very insightful by the panel. The separation of powers doctrines on page 25, as expounded in Marbury, the case I told you about, and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of Congress's law, right? Congress makes the criminal statutes, not the Department of Justice. The Department of Justice in the executive branch applies the law created by the lawmaker, which is Congress, right? Article 1 of the Constitution. And so if you don't have Article 3 judges enforcing the law of Article 1 Congress, then you've got Article 2 presidents who are out of control and without any kind of checks and balance or supervision. And that can't be. Although the decision, which this section, again, I think is Judge Henderson, although certain discretionary acts may be insulated from judicial review, the structure of the Constitution mandates that the president is amenable to the laws for his conduct and cannot, at his discretion, violate them, citing Marbury. Here, former President Trump's actions allegedly violated generally applicable criminal laws, i.e. the work of Congress, meaning those acts were not properly within the scope of his lawful discretion. Accordingly, Marbury, from 1807, provide him no structural immunity from the charges in the indictment. And just to show you where John Marshall's head was at in 1807, and then followed up with cases in 1882, Marshall, in a case that he presided over as Chief Justice, again, the most influential Chief Justice of all time, John Marshall, he also presided over the Aaron Burr trial, the one that killed Hamilton. And in that trial, he has the famous quote that presidents come from the masses, right? They come from the public. They serve their time, whatever it's 1 term or 2 term, or they're taken out early on impeachment and removal, and then they return to the masses. That kind of really knocks the crown off Trump's head and knocks him off his perch and his high horse, that he's anything but now Citizen Trump, which is what the decision actually calls him at some point. He's back to being Citizen Trump at the point that he's trying to assert presidential immunity. And he's no greater than anybody else, including my audience here on this hot take. And I like the fact that they've knocked him down a number of pegs. Chief Justice Marshall, I want to cite to a quote from him because I think that's important. Here's how they describe Marbury versus Madison and Chief Justice Marshall. They start on page 21 by saying, former President Trump misreads Marbury. You'll hear that a lot on my hot takes. And its progeny. Properly understood, the separation of powers doctrine may immunize lawful discretionary acts, but does not bar the federal criminal prosecution of a former president for every official act. As the first category, Chief Justice Marshall in 1807 recognized, quote, the president is invested with certain important political powers, in the exercise of which is to use his own discretion and is accountable only to his country in his political character and to his own conscience. However, when the president or his appointed officers, his cabinet members, for instance, exercise discretionary authority, the subjects are political. Their discretionary acts cannot be examinable by the court. But, and this is the part, the but is the part that Donald Trump, this stubborn little exception is the part that Donald Trump's lawyers ignored. But when the legislature proceeds to impose on that officer other duties, criminal law, when he is directed peremptorily to perform certain acts or not perform them, when the rights of individuals are dependent on the performance of those acts, he, that president, is far from the officer of the law, is amenable to the laws for his conduct, That's the criminal laws, and cannot at his discretion sport away the vested rights of others. I love John Marshall. The question is, am I going to love John Roberts, our current Chief Justice, and what he does next? So I'm going to do separate hot takes. That's on the separation of powers. And you see that same argument raised in a recent brief just filed by Donald Trump earlier in the week, before he got the ruling from the D.C. Court of Appeals, in which they argued, there's nothing to see here, Supreme Court. You don't have Article 3 power to even review Donald Trump's actions or take him off the ballot. You can't find that he was an insurrectionist or rebelled against the Constitution under the Article 3 of the 14th Amendment. You can't ban him from a ballot. In fact, nobody can. Has to go back to Congress. Now suddenly Donald Trump wants Congress to regulate his conduct or not. Whereas in this argument, he's arguing that Congress's laws can be completely ignored by Donald Trump. Do you see the fallacy? Do you see the flip-flop of positions that are going to ultimately be his demise in terms of his arguments? And here he's using the separation of powers to argue there's some sort of structural immunity that he can't be reviewed by an Article 3 judge. And he's telling the United States Supreme Court, you can't review my actions either. You can't take me off the ballot. Only Congress can. See, he's always playing whack-a-mole, right? And hide the ball about which branch can review him, and the separation of powers issue. He's going to lose by arguing to the United States Supreme Court, as he is right now, that they don't have the power to decide, or no federal judge has the power to decide whether Donald Trump should or should not be on the ballot. I believe the 14th Amendment, Section 3 is self-executing. Follow me for an interview that I'm going to be doing later in the week for Legal AF on a special with Judge Michael Luttig, former federal judge, who's written many amicus friends of the court briefs and is a rock-ribbed Republican and member of the Federalist Society, who his opinions matter. We're going to be interviewing him after we hear the oral argument this week at the United States Supreme Court level. In the meantime, that's my breakdown of what's going on with Donald Trump on the separation of powers argument and how it impacts the oral argument later this week at the Supreme Court level on the 14th Amendment ballot banning issue. If you like what I'm doing, leave me a thumbs up and follow me on Legal AF on Wednesdays and Saturdays at 8 p.m. Eastern Time, only right here on the 2 million strong, soon to be 3 million strong MeidasTouch network. Till my next hot take, till my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.